5 DCCR 0979.
All right, folks, buckle up. We're diving straight into a real Texas courtroom where one small decision could mean freedom or years behind bars. Watch closely. Even the judge's tone here tells us this case isn't just routine.
There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I assume the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognized.
Notice how the defense lawyer is already setting expectations. This is called damage control sentencing. He's basically saying, Judge, we know it's bad, but please keep it on the lighter end. Smart strategy, but will it work?
The error of what she did, she's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened and hopefully not engage in the type of conduct that caused us to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer.
Whoa, did you catch that? A death case that spiraled from a shoplifting attempt. This is where small crimes turn catastrophic. Imagine how fast this escalated from theft to a life-altering tragedy.
Initiate some sort of contact with him. It was, or her. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So obviously, if the court repeats fine, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address it as well. Is that right? You have to say what you said.
I apologize for the situation that went on, and I wish that anybody that was involved in the case would see that I'm really serious, and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a waiver.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report where you were put in the parish jail. And then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies that ended up with you going to prison. 5 years it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just
Here's the turning point. Because an officer got hurt, this isn't just shoplifting anymore. It's assault on a peace officer. A felony with serious prison time. Think about it. Should intent matter here, or just the result?
what went on with you and that officer is ridiculous, you know? because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery. Sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
The wrong case number.
I did.
You went on the robbery, and we actually entered the plea on the assault.
Sorry, 25 DCCR 0979
That's the assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I just say on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated.
Okay.
All right. And we have to have that discovery certification today because the case is going to get to close
Not
down.
again, you never gave it to me.
Well, I mean, when she first pled.
So do I?
You didn't give
You
it.
to give me
Still
a
got the credit for me being in here on this.
Yes, all the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you. See what y'all want. All right, ma'am, you're Crystal Vogan. And Ms. Vogan, you were here yesterday.
All right, new defendant, new story. But notice how seamlessly the court moves from one life to another. For the judge, this is case number 2 of the morning. For the accused, it's the most important day of their life.
For sentencing and cause number 25 DCCR 0026. Just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is?
Well, Judge, yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, to the court, for her actions yesterday. Did explain to her as far as where we were as the case, the rejection was there on the deferred. You did kind of put at that point it would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understands how it may affect her with her job, but she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower?
Judge, in light of all that the court's already mentioned and cited, we're going to leave it to the court, but we would not be inclined to put her on probation after the way she acted and due to her criminal history. So we would, if the court wants to allow her to do straight, that's fine. I understand.
Yeah, well, that's what your argument was yesterday.
It was.
To continue, for me to go forward. So, I mean,
True.
the most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday. And if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation. And then I can kind of reinstate everything up to the plea and all of that, so we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with sentencing. Is that everyone's agreement?
That's fine, Mr. Judge.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change. And that's what everyone's agreement is. Is that correct? And it is, I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay. All right, then what I'm going to do, let's see, restitution. And the restitution will be that 10,000. And that's everyone's agreement as well, correct?
Yes, correct.
All right, then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 fine, restitution, and to follow all of the rules and conditions of probation. If you do this, this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you.
That's the fine line in probation. It sounds like a second chance, but it's really a test of discipline. One slip and the hammer comes down. Do you think probation truly helps people reform, or just delays the inevitable?
You understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI, but y'all can throw that away.
Orders, but I have them.
You have them? Okay.
Judge, if it's okay with the court as well, we want to apologize to you.
Yes, ma'am.
I'm very sorry. I was going through a lot, which I understand is not an excuse. And I do apologize for my actions and behavior.
I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, if you disagree, you disagree. But you have to do everything they said. You have to be cordial. Thank you for your apology.